Conchita Carpio Morales, in her capacity as the Ombudsman, Petitioner, versus Court of Appeals, 6th Division, and Jomar Irwin S. Binay, Jr., Respondents. GR numbers 217126-27. November 10, 2015.
Case assigned to me is case number 46, Conchita Carpio Morales, in her capacity as the Ombudsman, Petitioner, versus Court of Appeals, 6th Division, and Jomar Irwin S. Binay, Jr., Respondents. GR Nos. 217126-27. November 10, 2015. This controversial special civil action is a 156-pager case, but I only culled out the essential facts, issue and ruling relevant to our topic for today. At the outset of the subject petition for certiorari and prohibition, the justices of the 6th Division, with Justice Perlas Bernabe as the ponent, emphasized the principle of Jeremy Bentham, which is of my opinion is the very heart of this case, that is, all government is a trust, every branch of government is a trust, and immemorially acknowledged so to be.
To start with, this case is a petition for certiorari and prohibition filed on March 25, 2015 by petitioner Conchita Carpio Morales, in her capacity as the Ombudsman, through the Office of the Solicitor General, OSG, assailing.
The resolution dated March 16, 2015 of Public Respondent the Court of Appeals CA, in CAGRSP number 139453, which granted private respondent Jomar Irwin S. Binay Jr.'s prayer for the issuance of a temporary restraining order (TRO) against the implementation of the joint order dated March 10, 2015 of the Ombudsman in OM CA 150058-0063 preventive suspension order, preventively suspending him and several other public officers and employees of the city government of Makati, for 6 months without pay, and b. the resolution dated March 20, 2015 of the CA, ordering the Ombudsman to comment on Binay Jr.'s petition for contempt in CAGR. SP number 139504. Pursuant to the resolution dated April 6, 2015, the CA issued a writ of preliminary injunction WPI in CAGR. SP number 139453, which further enjoined the implementation of the preventive suspension order, prompting the Ombudsman to file a supplemental petition on April 13, 2015.
This case started on July 22, 2014, when a complaint affidavit was filed by Atti. Renato L. Bondal and Nicholas Ching, in CISO v. before the Office of the Ombudsman against Binay Jr. and other public officers and employees of the city government of Makati, Binay Jr., et al., accusing them of plunder and violation of Republic Act No. RA. 3019, otherwise known as the Anti-Graft and Corrupt Practices Act, in connection with the 5 phases of the procurement and construction of the Makati City Hall Parking Building. Makati Parking Building.
On September 9, 2014, the Ombudsman constituted a special panel of investigators to conduct a fact-finding investigation, submit an investigation report, and file the necessary complaint, if warranted. First special panel, pursuant to the Ombudsman's directive, on March 5, 2015, the first special panel filed a complaint, complaint, against Binay Jr., et al., charging them with 6 administrative cases for grave misconduct, serious dishonesty, and conduct prejudicial to the best interest of the service, and 6 criminal cases for violation of Section 3 of RA 3019, malversation of public funds, and falsification of public documents, cases. The Ombudsman, upon the recommendation of the second special panel, issued on March 10, 2015, the subject preventive suspension order, placing Binay Jr., et al., under preventive suspension for not more than 6 months without pay, during the pendency of the cases.
On March 11, 2015, a copy of the preventive suspension order was sent to the office of the city mayor, and received by Maricon Austin, a member of Binet Jr.'s staff. On even date, Binet Jr. filed a petition for certiorari before the CA, docketed as CAGRSP number 139453, seeking the nullification of the preventive suspension order, and praying for the issuance of a TRO and/or WPI to enjoin its implementation.
Primarily, Binet Jr. argued that he could not be held administratively liable for any anomalous activity attending any of the five phases of the Makati parking building project since
Phases I and II were undertaken before he was elected mayor of Makati in 2010, and B. Phases 3 to V transpired during his first term, and that his re-election as city mayor of Makati for a second term effectively condoned his administrative liability therefore, if any, thus rendering the administrative cases against him moot and academic.
In so ruling, the CA found that Binet Jr. has an ostensible right to the final relief prayed for, namely, the nullification of the preventive suspension order, in view of the condonation doctrine, citing Aguinaldo versus Santos. Particularly, it found that the Ombudsman can hardly impose preventive suspension against Binet Jr. given that his re-election in 2013 as city mayor of Makati condoned any administrative liability arising from anomalous activities relative to the Makati parking building project from 2007 to 2013. In this regard, the CA added that, although there were acts which were apparently committed by Binet Jr. beyond his first term, namely, the alleged payments on July 3, July 4, and July 24, 2013, corresponding to the services of Hillmarks and Mana. Still, Binet Jr. cannot be held administratively liable therefore based on the cases of Salalima v. Gangona Jr., and Mayor Garcia versus Mojica wherein the condonation doctrine was still applied by the court although the payments were made after the official's re-election, reasoning that the payments were merely effected pursuant to contracts executed before said re-election. To this, the CA added that there was no concrete evidence of Binet Jr.'s participation for the alleged payments made on July 3, 4, and 24, 2013.
Now, out of 5 identified issues, the issue relevant to our topic tonight is whether the CA gravely abused its discretion in issuing the TRO and eventually, the WPI in CAGRSP number 139453 enjoining the implementation of the preventive suspension order against Binet Jr. based on the condonation doctrine.
Ruling, the Supreme Court ruled that the petition is partly meritorious. For in-depth analysis and better understanding of this case, the Supreme Court further explained what, how and why the condonation doctrine was used as basis for this case.
The origin of the condonation doctrine. According to the SC, generally speaking, condonation has been defined as a victim's express or implied forgiveness of an offense, especially by treating the offender as if there had been no offense. The condonation doctrine, which connotes this same sense of complete extinguishment of liability as will be herein elaborated upon, is not based on statutory law. It is a jurisprudential creation that originated from the 1959 case of Pascual versus Hun. Provincial Board of Nueva Ecija, which was therefore decided under the 1935 Constitution. As there was no legal precedent on the issue at that time, the court, in Pascual, resorted to American authorities and found that cases on the matter are conflicting due in part, probably, to differences in statutes and constitutional provisions, and also, in part, to a divergence of views with respect to the question of whether the subsequent election or appointment condones the prior misconduct.
According to the SC, election is not a mode of condoning an administrative offense, and there is simply no constitutional or statutory basis in our jurisdiction to support the notion that an official elected for a different term is fully absolved of any administrative liability arising from an offense done during a prior term.
Concept of public office is a public trust and the corollary requirement of accountability to the people at all times, as mandated under the 1987 Constitution, is plainly inconsistent with the idea that an elective local official's administrative liability for a misconduct committed during a prior term can be wiped off by the fact that he was elected to a second term of office, or even another elective post. Relatedly, it should be clarified that there is no truth in Pascual's postulation that the courts would be depriving the electorate of their right to elect their officers if condonation were not to be sanctioned. In political law, election pertains to the process by which a particular constituency chooses an individual to hold a public office. In this jurisdiction, there is, again, no legal basis to conclude that election automatically implies condonation. Neither is there any legal basis to say that every democratic and republican state has an inherent regime of condonation. If condonation of an elective official's administrative liability would perhaps be allowed in this jurisdiction, then the same should have been provided by law under our governing legal mechanisms. May it be at the time of Pascual or at present, by no means has it been shown that such a law, whether in a constitutional or statutory provision, exists. Therefore, inferring from this manifest absence, it cannot be said that the electorate's will has been abdicated.
Equally infirm is Pascual's proposition that the electorate, when re-electing a local official, are assumed to have done so with knowledge of his life and character, and that they disregarded or forgave his faults or misconduct, if he had been guilty of any. Suffice it to state that no such presumption exists in any statute or procedural rule. Besides, it is contrary to human experience that the electorate would have full knowledge of a public official's misdeeds.
The Ombudsman correctly pointed out the reality that most corrupt acts by public officers are shrouded in secrecy and concealed from the public. Misconduct committed by an elective official is easily covered up, and is almost always unknown to the electorate when they cast their votes. At a conceptual level, condonation presupposes that the condoner has actual knowledge of what is to be condoned. Thus, there could be no condonation of an act that is unknown. The court, citing Civil Service Commission v. Sojer, 554 SCRA 160, 2008 also clarified that the condonation doctrine would not apply to appointive officials since, as to them, there is no sovereign will to disenfranchise. For local elective officials like Binet Jr., the grounds to discipline, suspend or remove an elective local official from office are stated in Section 60 of Republic Act No. 7160, otherwise known as the Local Government Code of 1991 LGC. Section 40B of the Local Government Code LGC states that those removed from office as a result of an administrative case shall be disqualified from running for any elective local position. Related to this provision is Section 40B of the LGC, which states that those removed from office as a result of an administrative case shall be disqualified from running for any elective local position. Section 66B of the LGC prohibits the enforcement of the penalty of suspension beyond the unexpired portion of the elective local official's prior term, and likewise allows said official to still run for re-election. However, as previously stated, nothing in Section 66B states that the elective local official's administrative liability is extinguished by the fact of re-election. Thus, at all events, no legal provision actually supports the theory that the liability is condoned. Therefore, the petition was partly granted and that the condonation doctrine was abandoned, but the abandonment is prospective in effect. The CA was directed to act on Respondent Binet Jr.'s petition for certiorari in CAGR. SP number 139453 in light of the Office of the Ombudsman's supervening issuance of its joint decision dated October 9, 2015 finding Binet Jr. administratively liable in the 6 administrative complaints, and after the filing of Petitioner Ombudsman Conchita Carpio Morales' comment, the CA was directed to resolve Binet Jr.'s petition for contempt in CAGR. SP number 139504 with utmost dispatch.
I'm Mr. Alvin Rojas, your reporter. Thank you for watching.